Hey folks, welcome to the Law of Self-Defense Show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you very much. And welcome to my ongoing reading of D.C. v. Heller, a seminal U.S. Supreme Court decision on the Second Amendment, the first of 3 such decisions I'll be reading in coming days. This is part 3 of 4 of my reading of D.C. v. Heller. Here we go. Hey folks, if you like this Law of Self-Defense content, and I know you do, that's why you're here, you may as well consider picking up a free copy of our best-selling book, The Law of Self-Defense Principles. It's a real physical book. It's not just a PDF download. You can check it out on Amazon, where it's 5-star rated, over 1,400 reviews, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free. You can get this book, learn more about it at lawofselfdefense.com/free book. Pre-Civil War case law. The 19th century cases that interpreted the Second Amendment universally support an individual right unconnected to militia service. In Houston v. Moore, 1820, this court held that states have concurrent power over the militia, at least were not preempted by Congress. Agreeing in dissent that states could organize, discipline, and arm the militia in the absence of conflicting federal regulation, Justice Story said that the Second Amendment may not, perhaps, be thought to have any important bearing on this point. If it have, it confirms and illustrates rather than impugns the reasoning already suggested. Of course, if the amendment simply protected the right of the people of each of the several states to maintain a well-regulated militia, Stevens dissenting, it would have enormous and obvious bearing on this point. But the court and Story derived the state's power over the militia from the non-exclusive nature of federal power, not from the Second Amendment, whose preamble merely confirms and illustrates the importance of the militia. Even clearer was Justice Baldwin in the famous fugitive slave case of Johnson v. Tompkins, 1833. Baldwin, sitting as a circuit judge, cited both the Second Amendment and the Pennsylvania analog for his conclusion that a citizen has a right to carry arms in defense of his property or person, and to use them if either were assailed with such force, numbers, or violence as made it necessary for the protection or safety of either. Close quote. Many early 19th century state cases indicated that the Second Amendment right to bear arms was an individual right unconnected to militia service, though subject to certain restrictions. A Virginia case in 1824 holding that the Constitution did not extend to free blacks explained that numerous restrictions imposed on blacks in our statute book, many of which are inconsistent with the letter and spirit of the Constitution, both of this state and of the United States as respects the free whites, demonstrates that here those instruments have not been considered to extend equally to both classes of our population. We will only instance the restriction upon the migration of free blacks into the state and upon their right to bear arms. Close quote. The claim was obviously not that blacks were prevented from carrying guns in the militia. An 1829 decision by the Supreme Court of Michigan said, quote, "The Constitution of the United States also grants to the citizen the right to keep and bear arms, but the grant of this privilege cannot be construed into the right in him who keeps a gun to destroy his neighbor. No rights are intended to be granted by the Constitution for an unlawful or unjustifiable purpose." Close quote. It is not possible to read this as discussing anything other than an individual right unconnected to militia service. If it did have to do with militia service, the limitation upon it would not be any unlawful or unjustifiable purpose, but any non-military purpose whatsoever. In Nunn v. State, 1846, the Georgia Supreme Court construed the Second Amendment as protecting the natural right of self-defense, and therefore struck down a ban on carrying pistols openly. Its opinion perfectly captured the way in which the operative clause of the Second Amendment furthers the purpose announced in the prefatory clause, in continuity with the English right. Quote, "The right of the whole people, old and young, men and women and boys, and not militia only, to keep and bear arms of every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree, and all this for the important end to be attained, the rearing up and qualifying a well-regulated militia, so vitally necessary to the security of our free state. Our opinion is that any law, state or federal, is repugnant to the Constitution and void, which contravenes this right, originally belonging to our forefathers, trampled underfoot by Charles I and his two wicked sons and successors, re-established by the Revolution of 1688, conveyed to this land of liberty by the colonists, and finally incorporated conspicuously in our own Magna Charta." Close quote. Likewise, in State v. Chandler, 1850, the Louisiana Supreme Court held that citizens had a right to carry arms openly. This is the right guaranteed by the Constitution of the United States and which is calculated to incite men to a manly and noble defense of themselves, if necessary, and of their country, without any tendency to secret advantages and unmanly assassinations. Those who believe that the Second Amendment preserves only a militia-centered right place great reliance on the Tennessee Supreme Court's 1840 decision in Amet v. State. The case does not stand for that broad proposition. In fact, the case does not mention the word militia at all, except in its quoting of the Second Amendment. Amet held that the state constitutional guarantee of the right to bear arms did not prohibit the banning of concealed weapons. The opinion first recognized that both the state right and the federal right were descendants of the 1689 English right, but erroneously, and contrary to virtually all other authorities, read that right to refer only to protection of the public liberty and keeping in awe those in power. The court then adopted a sort of middle position whereby citizens were permitted to carry arms openly, unconnected with any service in a formal militia, but were given the right to use them only for the military purpose of banding together to oppose tyranny. This odd reading of the right is, to be sure, not the one we adopt, but it is not petitioner's reading either. More importantly, 7 years earlier, the Tennessee Supreme Court had treated the state constitutional provision as conferring a right of all the free citizens of the state to keep and bear arms for their defense. And 21 years later, the court held that the keep portion of the state constitutional right included the right to personal self-defense. Quote, "The right to keep arms involves, necessarily, the right to use such arms for all the ordinary purposes, and in all the ordinary modes usual in the country, and to which arms are adopted, limited by the duties of a good citizen in times of peace." Close quote. Post-Civil War legislation. In the aftermath of the Civil War, there was an outpouring of discussion of the Second Amendment in Congress and in public discourse, as people debated whether and how to secure constitutional rights for newly free slaves. Since these discussions took place 75 years after the ratification of the Second Amendment, they do not provide as much insight into its original meaning as earlier sources. Yet those born and educated in the early 19th century faced a widespread effort to limit arms ownership by a large number of citizens. Their understanding of the origins and continuing significance of the amendment is instructive. Blacks were routinely disarmed by southern states after the Civil War. Those who opposed these injustices frequently stated that they infringed blacks' constitutional right to keep and bear arms. Needless to say, the claim was not that blacks were being prohibited from carrying arms in an organized state militia. A report of the Commission of the Freedmen's Bureau in 1866 stated plainly, quote, "The civil law of Kentucky prohibits the colored man from bearing arms. Their arms are taken from them by the civil authorities. Thus, the right of the people to keep and bear arms as provided in the Constitution is infringed." Close quote. A joint congressional report decried, quote, "In some parts of South Carolina, armed parties are, without proper authority, engaged in seizing all firearms found in the hands of the freemen. Such conduct is in clear and direct violation of their personal rights as guaranteed by the Constitution of the United States, which declares that the right of the people to keep and bear arms shall not be infringed. The freedmen of South Carolina have shown by their peaceful and orderly conduct that they can safely be trusted with firearms, and they need them to kill game for subsistence and to protect their crops from destruction by birds and animals." Close quote. The view expressed in these statements was widely reported and was apparently widely held. For example, an editorial in the Loyal Georgian, Augusta, on February 3, 1866, assured blacks that, quote, all men, without distinction of color, have the right to keep and bear arms to defend their homes, families, or themselves, close quote. Congress enacted the Freedmen's Bureau Act on July 16, 1866. Section 14 stated, quote, the right to have full and equal benefits of all laws and proceedings concerning personal liberty, personal security, and the acquisition, enjoyment, and disposition of estates, real and personal, including the constitutional right to bear arms, shall be secured to and enjoyed by all the citizens without respect to race or color or previous condition of slavery, close quote. The understanding that the Second Amendment gave freed blacks the right to keep and bear arms was reflected in congressional discussion of the bill, with even an opponent of it saying that the founding generation, quote, were for every man bearing his arms about him and keeping them in his house, his castle, for his own defense, close quote. Similar discussion attended the passage of the Civil Rights Act of 1871 and the 14th Amendment. For example, Representative Butler said of the act, quote, Section 8 is intended to enforce the well-known constitutional provision guaranteeing the right of the citizen to keep and bear arms, and provides that whoever shall take away, by force or violence, or by threats and intimidation, the arms and weapons which any person may have for his defense, shall be deemed guilty of larceny of the same, close quote. With respect to the proposed amendment, Senator Pomeroy described as one of the three indispensable safeguards of liberty under the Constitution a man's right to bear arms for the defense of himself and family and his homestead. Representative Nye thought the 14th Amendment unnecessary because, quote, as citizens of the United States, blacks have equal right to protection and to keep and bear arms for self-defense, close quote. It was plainly the understanding in the post-Civil War Congress that the Second Amendment protected an individual right to use arms for self-defense. Post-Civil War commentators. Every late 19th century legal scholar that we have read interpreted the Second Amendment to secure an individual right unconnected with militia service. The most famous was the judge and professor Thomas Cooley, who wrote a massively popular 1868 treatise on constitutional limitations. Concerning the Second Amendment, it said, quote, among the other defenses to personal liberty should be mentioned the right of the people to keep and bear arms. The alternative to a standing army is a well-regulated militia, but this cannot exist unless the people are trained to bearing arms. How far it is in the power of the legislature to regulate this right, we shall not undertake to say, as happily there have been very little occasion to discuss that subject by the courts. Close quote. That Cooley understood the right not as connected to militia service, but as securing the militia by ensuring a populace familiar with arms is made even clearer in his 1880 work, General Principles of Constitutional Law. The Second Amendment, he said, quote, was adopted with some modification and enlargement from the English Bill of Rights of 1688, where it stood as a protest against arbitrary action of the overturned dynasty in disarming the people, close quote. In a section entitled The Right in General, he continued, quote, it might be supposed from the phraseology of this provision that the right to keep and bear arms was only guaranteed to the militia, but this would be an interpretation not warranted by the intent. The militia, as has been elsewhere explained, consists of those persons who, under the law, are liable to the performance of military duty and are officered and enrolled for service when called upon. But the law may make provision for the enrollment of all who are fit to perform military duty, or of a small number only, or it may wholly omit to make any provision at all, and if the right were limited to those enrolled, the purpose of this guarantee might be defeated altogether by the action or neglect to act of the government it was meant to hold in check. The meaning of the provision undoubtedly is that the people, from whom the militia must be taken, shall have the right to keep and bear arms, and they need no permission or regulation of law for that purpose. But this enables government to have a well-regulated militia, for to bear arms implies something more than the mere keeping. It implies the learning to handle and use them in a way that makes those who keep them ready for their efficient use. In other words, it implies the right to meet for voluntary discipline in arms, observing in doing so the laws of public order. Close quote. All other post-Civil War 19th century sources we have found concurred with Cooley. One example from each decade will convey the general flavor. Quote, "The purpose of the Second Amendment is to secure a well-armed militia, but a militia would be useless unless the citizens were enabled to exercise themselves in the use of warlike weapons. To preserve this privilege and to secure to the people the ability to oppose themselves in military force against the usurpations of the government, as well as against enemies from without, that government is forbidden by any law or proceeding to invade or destroy the right to keep and bear arms. The clause is analogous to the one securing the freedom of speech and of the press. Freedom, not license, is secured. The fair use, not the libelous abuse, is protected." Close quote. That's from 1868, J. Pomeroy, an introduction to the constitutional law of the United States. Quote, "As the Constitution of the United States and the constitutions of several of the states, in terms more or less comprehensive, declare the right of the people to keep and bear arms, it has been a subject of grave discussion in some of the state courts whether a statute prohibiting persons, when not on a journey or as travelers, from wearing or carrying concealed weapons be constitutional. There has been a great difference of opinion on the question." Close quote. That's from J. Kent, Commentaries on American Law, 1873. Quote, "Some general knowledge of firearms is important to the public welfare because it would be impossible in case of war to organize promptly an efficient force of volunteers unless the people had some familiarity with weapons of war. The Constitution secures the right of the people to keep and bear arms. No doubt, a citizen who keeps a gun or pistol under judicious precautions, practices in safe places the use of it, and in due time teaches his sons to do the same, exercises his individual right. No doubt, a person whose residence or duties involve peculiar peril may keep a pistol for prudent self-defense." Close quote. That's from B. Abbott, Judge and Jury, a popular explanation of the leading topics in the law of the land, 1880. Quote, "The right to bear arms has always been the distinctive privilege of freemen. Aside from any necessity of self-protection to the person, it represents among all nations power coupled with the exercise of a certain jurisdiction. It was not necessary that the right to bear arms should be granted in the Constitution, for it had always existed." Close quote. That's from J. Audrenoy, Constitutional Legislation in the United States, 1891. We now ask whether any of our precedents forecloses the conclusions we have reached about the meaning of the Second Amendment. United States v. Cruikshank, in the course of vacating the convictions of members of a white mob for depriving blacks of the right to keep and bear arms, held that the Second Amendment does not, by its own force, apply to anyone other than the federal government. The opinion explained that the right is not a right granted by the Constitution or in any manner dependent upon that instrument for its existence. The Second Amendment means no more than it shall not be infringed by Congress. States, we said, were free to restrict or protect the right under their police powers. The limited discussion of the Second Amendment in Cruikshank supports, if anything, the individual rights interpretation. There was no claim in Cruikshank that the victims had been deprived of the right to carry arms in a militia. Indeed, the governor had disbanded the local militia unit the year before the mob's attack. We described the right protected by the Second Amendment as bearing arms for a lawful purpose, and said that the people must look for their protection against any violation by their fellow citizens of the rights it recognizes to the state's police power. That discussion makes little sense if it is only a right to bear arms in a state militia. Presser v. Illinois, 1886, held that the right to keep and bear arms was not violated by a law that forbade bodies of men to associate together as military organizations or to drill or parade with arms in cities and towns unless authorized by law. This does not refute the individual rights interpretation of the amendment. No one supporting that interpretation has contended that states may not ban such groups. Justice Stevens presses Presser into service to support his view that the right to bear arms is limited to service in the militia by joining Presser's brief discussion of the Second Amendment with a later portion of the opinion, making the seemingly relevant to the Second Amendment point that the plaintiff was not a member of the state militia. Unfortunately for Justice Stevens' argument, that later portion deals with the 14th Amendment. It was the 14th Amendment to which the plaintiff's non-membership in the militia was relevant. Thus, Justice Stevens' statement that Presser suggested that nothing in the Constitution protected the use of arms outside the context of a militia is simply wrong. Presser said nothing about the Second Amendment's meaning or scope beyond the fact that it does not prevent the prohibition of private paramilitary organizations. Justice Stevens places overwhelming reliance upon this court's decision in United States v. Miller, 1939. Hundreds of judges, we are told, have relied on the view of the amendment we endorsed there, and even if the textual and historical arguments on both sides of the issue were evenly balanced, respect for the well-settled views of all our predecessors on this court and for the rule of law itself would prevent most jurists from endorsing such a dramatic upheaval in the law. And what is, according to Justice Stevens, the holding of Miller that demands such obsequience? That the Second Amendment protects the right to keep and bear arms for certain military purposes, but that it does not curtail the legislature's power to regulate the non-military use and ownership of weapons. Nothing so clearly demonstrates the weakness of Justice Stevens' case. Miller did not hold that and cannot possibly be read to have held that. The judgment in the case upheld against a Second Amendment challenge two men's federal convictions for transporting an unregistered, short-barreled shotgun in interstate commerce in violation of the National Firearms Act. It is entirely clear that the court's basis for saying that the Second Amendment did not apply was not that the defendants were bearing arms not for military purposes, but for non-military use. Rather, it was that the type of weapon at issue was not eligible for Second Amendment protection. Quote, in the absence of any evidence tending to show that the possession or use of a short-barreled shotgun at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Close quote. Certainly, the court continued, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. Beyond that, the opinion provided no explanation of the content of the right. This holding is not only consistent with, but positively suggests that the Second Amendment confers an individual right to keep and bear arms, though only arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Had the court believed that the Second Amendment protects only those serving in the militia, it would have been odd to examine the character of the weapon, rather than simply note that the true crooks were not militiamen. Justice Stevens can say again and again that Miller did not turn on the difference between muskets and sawed-off shotguns. It turned rather on the basic difference between the military and non-military use and possession of guns. But the words of the opinion prove otherwise. The most Justice Stevens can plausibly claim for Miller is that it declined to decide the nature of the Second Amendment right, despite the Solicitor General's argument, made in the alternative, that the right was collective. Miller stands only for the proposition that the Second Amendment right, whatever its nature, extends only to certain types of weapons. It is particularly wrong-headed to read Miller for more than what it said, because the case did not even purport to be a thorough examination of the Second Amendment. Justice Stevens claims that the opinion reached its conclusion after reviewing many of the same sources that are discussed at great length by the court today. Not many, which was not entirely the court's fault. The respondent made no appearance in the case, neither filing a brief nor appearing in oral argument. The court heard from no one but the government. Reason enough, one would think, not to make that case the beginning and the end of the court's consideration of the Second Amendment. The government's brief spent 2 pages discussing English legal sources, concluding that at least the carrying of weapons without lawful occasion or excuse was always a crime, and that because of the class-based restrictions and the prohibition on terrorizing people with dangerous or unusual weapons, the early English law did not guarantee an unrestricted right to bear arms. It then went on to rely primarily on the discussion of the English right to bear arms in Amet v. State, for the proposition that only uses of arms protected by the Second Amendment are those that relate to the militia, not self-defense. The final section of the brief recognized that some courts have said that the right to bear arms includes the right of the individual to have them for the protection of his person and property, and launched an alternative argument that weapons which are commonly used by criminals, such as sawed-off shotguns, are not protected. The government's Miller brief thus provided scant discussion of the history of the Second Amendment, and the court was presented with no counter-discussion. As for the text of the court's opinion itself, that discusses none of the history of the Second Amendment. It assumes from the prologue that the amendment was designed to preserve the militia, which we do not dispute, and then reviews some historical materials dealing with the nature of the militia, and in particular with the nature of the arms their members were expected to possess. Not a word about the history of the Second Amendment. This is the mighty rock upon which the dissent rests its case. We may as well consider at this point, for we will have to consider eventually, what types of weapons Miller permits. Read in isolation, Miller's phrase, part of ordinary military equipment, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, since it would mean that the National Firearms Act's restrictions on machine guns, not challenged in Miller, might be unconstitutional, machine guns being useful in warfare in 1939. We think that Miller's ordinary military equipment language must be read in tandem with what comes after. Ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. The traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. In the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same. Indeed, that is precisely the way in which the Second Amendment's operative clause furthers the purpose announced in its preface. We therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. That accords with the historical understanding of the scope of the rights. We conclude that nothing in our precedents forecloses our adoption of the original understanding of the Second Amendment. It should be unsurprising that such a significant matter has been for so long judicially unresolved. For most of our history, the Bill of Rights was not thought applicable to the states, and the federal government did not significantly regulate the possession of firearms by law-abiding citizens. Other provisions of the Bill of Rights have similarly remained unilluminated for lengthy periods. This court first held the law to violate the First Amendment's guarantee of freedom of speech in 1931, almost 150 years after the amendment was ratified. And it was not until after World War II that we held a law invalid under the Establishment Clause. Even a question as basic as the scope of prescribable libel was not addressed by this court until 1964, nearly 2 centuries after the founding. It is demonstrably not true that, as Justice Stevens claims, for most of our history, the invalidity of the Second Amendment-based objections to firearms regulations has been well settled and uncontroversial. For most of our history, the question did not present itself. Hey folks, that's it for part 3 of 4 of my reading of D.C. v. Heller. Next time we meet, I'll be reading part 4 of 4 of D.C. v. Heller. If you like this kind of content, and I know you do, that's why you're here, you may as well consider becoming a Law of Self-Defense member. It's dirt cheap to at least try it out. You can get a 2-week trial membership for only 99 cents. Just go to lawofselfdefense.com/trial to sign up for that. In the unlikely event you don't like it and you'd like your money back, we'll give you a 200% refund. Most people, almost everyone, stays a member, and just being a standard member of Law of Self-Defense is dirt cheap. It's only about 30 cents a day, less than $10 a month. To be a member of Law of Self-Defense, get unlimited access to all our members-only content. It's the only way to have your comments and questions on live streams be addressed by me. You get a members-only podcast. Much of our content is limited, so only members can access it. Get all that and much more at lawofselfdefense.com/trial. Just try it out for 2 weeks, 99 cents, 200% money back guarantee. It's a negative risk opportunity. I hope you see you as a member real soon.